So again, shout out to Beck in the chat and to Thugger Daily for getting this to us. What a great hodgepodge day of all these different things. Now we are going to look at this, and you can see it was filed yesterday. It registered through at 4 p.m. And this is in the Supreme Court, State of Georgia. Brian Steele's the appellant, and the State of Georgia is the appellee. This is in relation to the contempt. So, brief of Georgia Association of Criminal Defense Lawyers, so GACDL, as amicus curiae in support of appellant Brian Steele. So, namely writing this, we have new names. Well, we might know some of these names, but they're different from the names on the previous amicus brief. We've got Hunter Rogers, Maisie Lynn Burton, Jessica Jones, Greg Willis. And, they're going to give us table of contents. This is always how amicus briefs should be filed. What are you here for? What's your general argument? And we get a good summary from this table of contents here. So, one of the arguments is Attorney Steele was vigorously advocating on behalf of his client, and his refusal to violate attorney-client privilege is not criminal contempt. So that's one of the arguments we're going to see. And B, Judge Glanville should have recused himself from the contempt proceedings because he provoked the extraordinary circumstances giving rise to the alleged contempt and became personally embroiled with Attorney Steele. So if you ever want to get the top level, amicus briefs always should contain a table of contents like this, or they could be rejected. So let's get into it. And again, why this is so long, they have the June 10th transcript attached, as well as the supplement from Doug Weinstein, the supplement to Diamante Kendrick's motion for mistrial, which also contained the June 7th ex parte transcript. So this brief is going to look at both of those transcripts for the two different ex partes that we know about. Now we're going to skip some of the tables of authorities, but you can see how much case law goes into something like this. This is a whole page. And then we get a bunch of statutes that are going to be applicable, and then some others. And when you see stuff referenced like this, this is usually highly credentialed legal analysis that we're referencing because it's almost like an expert witness when you see stuff under and other cited in an amicus brief. Now, they have to state their interest as friends of the court. Amicus means you're a friend of the court, and you're filing this on interest maybe not just of the defendant themselves, but of a greater principle, of a greater concern for society. So the Georgia Association of Criminal Defense Lawyers, we're going to call that GACDL for the rest of the document, is a private member-funded, is a private member-funded statewide organization, be careful about that word organization, comprised largely of criminal defense lawyers. GACDL has a particular interest in the proper application and development of Georgia's criminal law, particularly when it involves a defense attorney's right to vigorously advocate on behalf of a client. GACDL has a vested interest in ensuring that defense attorneys are not subjected to criminal sanctions for fulfilling their ethical duties. This includes the duty of maintaining the sanctity of the attorney-client privilege relationship and attorney-client privilege communications. Punishing an attorney for fulfilling their duties sets a dangerous precedent that could severely chill the defense bar's ability to provide competent and ethical representation to defendants facing criminal charges. So you can see right here from this paragraph, even though this is being filed kind of on behalf of the appellant, that party, which is Brian Steele, they're stating a broader interest. GACDL members strive to be vigorous advocates, and as the United States Supreme Court held in Maness v. Myers, 419 U.S. 449 and 1975 case, an advocate should never be subjected to the penalty of contempt for protecting a client's rights in good faith. GACDL firmly insists that all defense attorneys in Georgia must be free from the threat of contempt for respectfully and honestly disagreeing with the trial court, making a record, and refusing to breach attorney-client privilege. To hold otherwise, what's the problem if we don't do this and protect this? To do otherwise, to hold otherwise, would discourage defense attorneys from vigorously advocating on behalf of their clients and encourage judges to abuse their power. So this is our impetus, this is our why, our mission. This is particularly true when the attorney is trying to protect a client in the center of an important controversy with a determined judge attempting to impose his personal will on the attorney with whom he has become personally embroiled. GACDL urges this honorable court to find that holding an attorney in criminal contempt for refusing to violate attorney-client privilege not only harms the attorney-client relationship, but also jeopardizes the proper administration of justice in all cases. So the ripple would go across the entire ocean. Now, factual background. So we're going to hear some things that are repeated, but remember, the Supreme Court might not be aware of absolutely everything. So the factual background helps the judges on the Supreme Court get a background on what was going on. It's the context within which they'll consider this amicus brief argument. Amicus adopts, it's amicus, whatever. I'm going to do that panel on pronunciations one day, I promise. The amicus adopts and supplements the statement of facts in appellant's brief. On Friday, June 7th, 2024, Chief Judge Glanville advised all parties in open court that he would address whether witness Kenneth Copeland, here we're going to just call him Copeland, intended to testify the following Monday, June 10th, 2024. Judge Glanville told all parties to return at 8:30 a.m. on Monday, including Copeland's counsel. Judge Glanville did not take the bench until 11:52 a.m. on Monday, June 10th, and gave no explanation for the nearly 3.5-hour delay. Judge Glanville did not inform the defense, including attorney Brian Steele, counsel for Jeffrey Williams, of the existence or substance of that morning's ex parte hearing involving the court, prosecutors, Copeland's counsel, and other court personnel. And they cite the June 10th transcript. I think that's really to get us a listing of who was present. That's what they're citing here for pages 4 or 5. The court did not disclose Copeland's exculpatory statements made in chambers to the defense. So, Brady material. After taking the bench on June 10th, 2024, Judge Glanville called the roll and asked the state if there was anything he needed to take up before Copeland was called to testify. And then the state says, "Nothing from the state, Your Honor." Mr. Steele, you don't have to if you don't want to. That's okay. Attorney Steele says, "I want to." Judge Glanville, "All right, go ahead." Attorney Steele, "I don't think what's going on. Last I heard, you said there would be a hearing this morning with his lawyer." I think I read that wrong. "I don't know what's going on. Last I heard, you said there would be a hearing this morning with his lawyer, and we have been in the dark since." Glanville, "Okay, Mr. Copeland had the opportunity to speak with his lawyer, Ms. Bumpus, and it is my understanding he's going to testify. That is the latest I can give you, okay? So we're going to bring Mr. Copeland out and see what happens." So, great summary by Glanville of what happened in that 3 hours. Oh yeah, he talked to his lawyer, that was it. After the lunch break, Attorney Steele made a motion citing his constitutional obligations under 6th and 14th Amendments to the United States Constitution and the corresponding sections of the Georgia Constitution, requiring Steele to make a full and complete statement to the court. The jury was not present. While Attorney Steele was disclosing what he learned about the ex parte hearing that took place that morning, Judge Glanville interrupted and said, "How did you find out about any of that?" Attorney Steele informed Judge Glanville that he was not going to answer the question, citing attorney-client privilege and attorney work product privilege under Rule 16 of Georgia Rules of Professional Conduct. Attorney Steele, "You should have told me. What I want to know is why I wasn't there." Judge Glanville was personally offended by this. When Judge Glanville told Attorney Steele he had 5 minutes to give him an answer, Attorney Steele responded that he did not need 5 minutes and he wanted to continue. Judge Glanville did not allow Attorney Steele to continue and left the bench while Attorney Steele was doing his best to make a record. Judge Glanville later acknowledged that Attorney Steele had a right to make a motion after learning about the ex parte hearing, but claimed that Attorney Steele put himself in a particular position he's in regarding the alleged contempt. In addition to preventing Attorney Steele from making a full and complete record, Judge Glanville did not allow Attorney Steele to properly respond to the allegations of contempt. Judge Glanville told Attorney Steele, "I don't want to know about your problems at this point in time." Judge Glanville was only concerned with how Attorney Steele learned about the ex parte hearing. And this is quotes, "not the substance of information Mr. Steele received or whether the ex parte conversation was proper." When Attorney Steele asked Judge Glanville why they could not discuss the substance without him having to provide his source, Judge Glanville responded, "Because you got some information that you shouldn't have gotten." Is anyone else, even though we've gone through this, we've seen it, we've watched it, is anybody else feeling like they're taken back to the moment and getting irritated about it all over again? Let me keep going. Judge Glanville accused Attorney Steele of hiding behind Rule 16. When Attorney Steele cited Comment 5 of Rule 16, Judge Glanville responded, "You can't violate something and then use the privilege." Judge Glanville oddly explained that the privilege in 1-6 would occur if you were in the right place, right time to begin with. You weren't. Yeah, so put him in a catch-22. Judge Glanville claimed that somehow Attorney Steele had surreptitiously gotten information in regard to the court's private ex parte conversation with a party. Judge Glanville accused Attorney Steele of eavesdropping to get information that was not meant for him to hear at that particular point in time. Judge Glanville accused Attorney Steele of contorting and perverting the process by getting information they shouldn't have had, and then saying the court did something wrong and that we should be entitled to have the transcript. Judge Glanville accused Attorney Steele of getting the information allegedly from an improper methodology, from one of two ways. He either eavesdropped, or somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible. I think that he had a conversation with somebody and he got some information that he shouldn't have gotten to begin with. Now, one other thing I'm noticing as we're reading this, are you guys noticing something repeated very often that we don't see in, when the other judges or the state talks about this issue? What are we seeing repeated over and over again? What phrase? What are we seeing the difference here? And yeah, you guys are saying we've got some feeling like it's happening all over again, feeling the same way. But we've got a phrase that these attorneys from GACDL have no shame in using as much as they can. Ex parte, ex parte, ex parte, ex parte. We're not calling it an in-chambers meeting. So we'll continue here. So Judge Glanville accused Attorney Steele of putting the court at a disadvantage because I didn't invite you into that particular proceeding and I don't think you had the right to be there. Judge Glanville accused Attorney Steele of, quote, running a very thin professional responsibility line when Attorney Steele requested a hearing with all witnesses who were present during the ex parte communications. Judge Glanville continued, I don't think that you have cover at this point in time. I think that you have blown your coverage at this point because I do think that somebody told you some things that violate privilege. Judge Glanville alleged that Attorney Steele and other lawyers for the defendants got the information in a way that was not lawful to begin with. A prosecutor acknowledged that she did not know if the information was leaked to Attorney Steele's client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. I love reading this because it really hones down that the state, they're giving two possibilities, but both of those possibilities operate on the premise that it was a leak. And a leak implies what? That it's something that shouldn't have happened, shouldn't have been disclosed. And what's the ultimate problem here if we have exculpatory information going down at this in-chambers ex parte meeting? Exculpatory information should be closed, whether or not they held that meeting with or without defense present. But the two options we're getting from the prosecutor, who the court is backing up, it was either leaked or it was leaked. And the judge is saying you had no right to come across that information. So you must have been eavesdropping or got it surreptitiously some other way. It's great reading this. After holding Attorney Steele in contempt that afternoon, Judge Glanville sought to go forward with trial without Attorney Steele present. Judge Glanville accused Steele's co-counsel, Attorney Keith Adams, of extorting the court by refusing to go forward without Attorney Steele. An appellate court will review my decision for abuse of discretion. Well, here we are. According to Judge Glanville, Mr. Steele put himself in this particular position by refusing to disclose his source. Judge Glanville eventually allowed Attorney Steele to continue representing Mr. Williams at trial after the state requested that he do so. Judge Glanville told Attorney Steele that he would be taken into custody whenever they finished court that afternoon if he did not tell him his source. Judge Glanville alleged that Attorney Steele interfered with his ability to administer justice because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. Judge Glanville's order finding Attorney Steele in contempt is devoid of facts showing that Attorney Steele posed an actual or imminent threat to the administration of justice. The order also failed to identify facts showing that Attorney Steele knew or should have known his refusal to answer the judge's questions about his source exceeded the bounds of permissible advocacy. So, even if the Georgia Supreme Court doesn't care about any of this, the context, the backing context, which I think was laid out great, the actual contempt order was deficient on the elements needed. So this paragraph is a short, concise, kind of separate issue that tacks onto this. Judge Glanville denied Attorney Steele a contested criminal contempt hearing before an impartial judge. When attorney Ashley Merchant, counsel for Attorney Steele, asked Judge Glanville to recuse himself from the contempt proceedings because he was a witness, Judge Glanville responded, "I'll let an appellate court decide that." Attorney Steele was singled out as the only attorney held in direct summary criminal contempt or questioned about the source of information regarding the ex parte hearing, despite other defense counsel having the same information. Judge Glanville acknowledged he was not asking other defense counsel about the source. "Well, I asked him, so I didn't ask you." Judge Glanville sentenced Attorney Steele to the maximum jail sentence and denied Attorney Steele a supersedeas bond without good cause, which we know the Supreme Court ended up granting. So this is an interesting paragraph here too, because, it makes sense to me once it's laid out, but I just didn't really give consideration to, it's also an additional issue if you're not holding other criminal defense attorneys for coming upon the same information. And then you explicitly state, "Well, I asked them, so I didn't ask you," as your reason for focusing on one only. So great, great stuff. Judge Glanville decided sua sponte, so that means on their own, without a prompting from either party, to seal the transcript and would not release it to the defendants or counsel for Attorney Steele. When Attorney Merchant asked for a copy of the transcript because it is germane to the contempt, Judge Glanville replied, "It's an ex parte matter, so you're not going to get it unless the appellate court wants to see if it's accepted. But I'm not going to give it to you at this point in time." Earlier that day, Glanville had stated, and we caught this, you guys, the chat was calling this out in real time. After Ashley Merchant said that in court and got denied by Judge Glanville, everyone was like, "Wait, he said earlier, we record these conversations so they can be reviewed later. If and when the case gets reviewed, an appellate court will make those decisions. When the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me." Imagine reading this as one of the Supreme Court judges presiding over this. Isn't this just kind of like poking the bear? Okay, sure, we'll tell you. It is recorded and taken down, so if it needs to be reviewed later, it gets reviewed. Judge Glanville said he was not going to order the transcript as of yet, because if the case should be reviewed, the appellate court would have that particular ability to do that. Judge Glanville reversed his position and subsequently entered an order on July 1st, 2024, regarding his decision to release the entirety of the transcript of the June 10th, 2024 ex parte conversation. The transcript of the June 10th, 2024 ex parte hearing revealed that Judge Glanville told Copeland he, the court, wanted to hear Copeland's testimony. Although the state initially requested the ex parte hearing, Judge Glanville implied it was the court when Copeland was brought into chambers. Look at the emphasis. If you guys aren't on the screen, I'm going to try to read it. Judge Glanville, so the first word of Judge Glanville speaking here from the transcript that's being cited is I. Me, I. It's bolded and it's underlined. Judge Glanville says, "I just wanted to bring you, Copeland, over and let you talk with your attorneys and see if there is anything that you need to ask of your counsel or Miss Prosecutor or the state or the court before we bring you out this morning, because it is, we would like to hear your testimony," and we is bolded and underlined. Copeland made numerous exculpatory statements to the judge, prosecutors, his counsel, and other court personnel. Quote, "I did these crimes, I'm telling you that." Quote, "I have never been truthful a day in my life until I just made this statement right now." Quote, "So I didn't tell you I lied on them to get myself out of the situation?" The prosecutor suggested how Copeland could testify about matters previously discussed. A prosecutor told Judge Glanville he, quote, "might want to close his ears," before informing Copeland he would not be prosecuted, quote, "if he confessed to a murder on the stand." And that's all in quotes. If the state did not have independent evidence. At one point, Copeland inquired about the statute of limitations for murder, an offense alleged in the underlying indictment. Copeland's involvement in the murder of Donovan Thomas is a substantive fact in issue. Substantive, U.S. pronunciation. Copeland was advised in the ex parte hearing that he would not be prosecuted for perjury even if they knew he was lying. Quote, "If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that." The prosecutor gave Copeland legal advice on various issues, including the statute of limitations for crimes she and Copeland discussed that she independently researched. The prosecutor told Copeland he, quote, had spent enough time in prison for YSL. Whether Copeland was incarcerated, quote, for YSL, was a substantive fact in issue. The prosecutor mentioned prior inducements for Copeland's testimony in the form of living arrangements. Now, this is a footnote here that says Copeland was not concerned about his safety. So remember, that was what they tried to hint, that it could have been for safety concerns. Copeland was advised that he could not be prosecuted for anything in federal court or other jurisdictions. The immunity order expressly states that Copeland, quote, shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other state. Holy moly, do I love reading that. There we go. This is GACDL. This is multiple defense attorneys saying, the advice he was given on this immunity order. This is the quote. This is the quote. Within the immunity order itself, contradicting what Hilton told Copeland in this ex parte meeting. Hallelujah. Doesn't this feel really validating? Doesn't it feel good to see some emphasis, because we've read this line on this stream. We've looked at it on X. We've talked about this, so many of us. But now we're seeing a bunch of attorneys like, hello, look at this quote. It says shall not. This is very, very validating. Thus, Copeland does not appear to have immunity in any court other than Fulton County Superior Court, pursuant to Judge Glanville's June 7th immunity order. Isn't that, look at that, the validation. There we go. There we go. Whew. And while I'm taking a breath here, shout out to, we had Amy E, the beautiful Amy E says, directed over here after Classy's live. Thanks so much for coming over, Classy. Y'all hit the like button for Kat. Happy Friday. And I'm sure, my mods are always on top of things. But here's a quick link drop just in case. And always love hanging out. I love to tune into Classy Beats, but I also love hanging out with Amy over in the chat over there. So make sure you go over there and hit the like button. It'll help you get your YSL content fix and then some. Thank you so much for showing the love and support, Amy and Classy. And Rice Street dropping 5 memberships. I see you guys. I was like, make Rice Street great again. What's going on in the chat? Rice Street's trying to bring in new members. Shout out to Rice Street, our resident Rice Street in the chat. Thank you so much. Mark in Texas says, big fat 0 on the credibility scale, talking about the Mungtuk pleas. I also think Love's threat to revoke went over like a lead balloon. Yeah, just like... I would love to see Love make an argument to rebuke yet somebody else at some point in the future. She's bound to keep trying. R for rebuke. Mark in Texas also says, S Satchel, my X handle. Oh yeah, we're gonna get some debating. Tom Telly Rand would have fun with discussions like this. And you know what? Mark in Texas, you have great insights. Let me drop your X. X.com. Because I love seeing you pop up on my feed. And I feel like there are some people in this chat that use X that are kind of on their own island on X. And if you guys are looking for more YSL people, you can share your handles in the chat. This is Mark in Texas because I have it handy. But super informative. I loved your insights on, the plea agreements in general. And I would love to see some back and forth there. Bilal sends the $1. Thank you so much, Bilal Brown. Happy Friday to you. Okay. And Steven Satchel, I'm not on any social media, sir. Love you guys both. Thank you for both bringing insights. And yeah, let's reread this last part. Let's reread this paragraph, you guys. Thank you, NJB. Let's look over here. Let's read this paragraph. I'm going to pull this off the screen so you can see the bottom. Well, I guess since it's another page, we'll do that. And this is a huge paragraph. So we go through all of these quotes about the things Copeland was saying. Can't I... The prosecutors say, he won't be prosecuted if he confessed to the murder on the stand. The judge should probably close the ears. Then Copeland inquires about the statute of limitations for murder, an offense alleged in the underlying indictment. Copeland's involvement in the murder of Donovan Thomas is a substantive fact and issue. Now, this is what we're going to really see argued, is the advisement. So we know that there's one issue of the exculpatory evidence not being disclosed by the state, and then the judge acting like the defense didn't have a right to it. But what about this legal advice given to Copeland? Copeland was advised in the ex parte hearing that he would not be prosecuted for perjury even if they knew he was lying. Quote, if I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. End quote. The prosecutor gave Copeland legal advice on various issues, including the statute of limitations for crimes she and Copeland discussed and that she independently researched. This is a very slick way of saying she independently researched and got it wrong. The prosecutor told Copeland that he had spent enough time in prison for YSL. Whether Copeland was incarcerated, quote, for YSL was a substantive fact and issue. Now, here's the beautiful part. The prosecutor mentioned prior inducements for Copeland's testimony in the form of living arrangements. Footnote says Copeland was not concerned for his safety. Copeland was advised that he could not be prosecuted for anything in federal court or other jurisdictions. The implication that between these lines here is they're doing this all just to induce his testimony. What does it take to induce testimony from Copeland? The promise that he would not go to jail, the promise that he would not have to do time. That's all he cared about. He wanted his freedom. The immunity order expressly states that Copeland, quote, shall not be required to produce evidence that can be used in any other court of the state, the United States, or any other state. Thus, Copeland does not appear to have immunity in any court other than Fulton County Superior Court, pursuant to Judge Glanville's June 7th, 2024 immunity order. So that's a huge paragraph. That is a huge, huge paragraph there. And I know we've all been like racking our brains like this immunity order doesn't seem gravy. How did they double down in court to say he's protected federally? And we've got highly credentialed. We have GACDL saying he's not actually protected in any other court except for Fulton County Superior Court under this order. So it goes on to say, another prosecutor disclosed attorney-client privilege information between Copeland and his counsel that the state, quote, overheard. They are going to hammer you. So the state is violating attorney-client privilege by disclosing onto the record what Melnick said. They said they overheard it. Quote, overheard. The prosecutor asserted in open court that the state was concerned, quote, information disclosed in an ex parte setting got relayed to the parties who were not privy to that. Bold, the whole purpose of the ex parte request was so that did not happen. There you go. Judge Glanville said the hearing was ex parte because that is what the state asked me to do. In his July 1st, they are hammering this down so beautifully. Like point for point. This is such a clear argument. I'm loving it. In his July 1st, 2024 order, Judge Glanville found that he complied with CJCR 29 by releasing the entirety of the transcript of the June 10th, 2024 ex parte conversation and providing the parties an opportunity to respond. Judge Glanville clarified in footnote 5 that, quote, the opportunity for the parties to respond will be reserved for later, subject to whether another judge finds the recusals warranted here. According to Judge Glanville, the only thing discussed between the state, counsel for Mr. Copeland, and this court was the understanding of Copeland's immunity agreement, which we know the result was still not him having clear understanding. Judge Glanville found that his June 10th, 2024 ex parte communications with the state were proper, pursuant to Rule 2.9, where no party gained any tactical advantage and where the transcript of the proceeding will be released. Judge Glanville's... Did I miss a footnote? Okay, no, I didn't. Judge Glanville's July 1st, 2024 order does not include any reference to the additional ex parte communications between prosecutors and Judge Glanville that occurred shortly after court ended, Friday, June 7th, 2024, the day Copeland was taken into custody for invoking his Fifth Amendment privileges. We have two footnotes in that sentence. So in the first half, we have Exhibit B citing, this is where we get the June 7th transcript brought in through the appendix, the exhibits here. They're citing Diamante Kendrick's motion for mistrial. And then footnote 3 says Judge Glanville refused to give Attorney Steele a copy of Copeland's immunity order when he asked for it on Friday, June 7th, 2024. Not yet, sir. It doesn't apply to you yet, Mr. Steele. The immunity order still had not been provided to Attorney Steele or any defendants when court resumed on Monday, June 10th, 2024. And I don't really, maybe they'll keep going. Maybe they'll get to this in a future page, but remember Shart, like, sometime later was still asking, we've still never seen the immunity order. So, the substance of the Friday, June 7th, 2024 ex parte hearing between the state and Judge Glanville was revealed to Attorney Steele and the defendants after Judge Glanville was recused from the case. During the Friday, June 7th, 2024 ex parte communication, so the Friday, a prosecutor advised Judge Glanville that the state would be looking for a remedy for, quote, Melnick's insertion of himself over the weekend, and that she wanted to inform Judge Glanville so that you are not caught off guard Monday morning or Saturday night or Saturday afternoon. We find it and send it to you. Exhibit B at 14. At the end of the meeting, Judge Glanville told the prosecutors, quote, if you find anything, we'll see where Monday leads us. And that's from Exhibit B. Melnick's interest was a concern that the prosecutor raised at the beginning of the Monday 10th, 2024 ex parte hearing, in line with the concern that she expressed on the record on Friday. According to Judge Glanville's July 1st, 2024 order, on the morning of June 10th, 2024, Judge Glanville was informed by his litigation manager that attorneys for the state requested an ex parte conversation with the court. The subject matter of the ex parte conversation is not told to the court in advance. And now argument and citation authority. So this might be some new stuff for us to look at, and this is where they try to argue Supreme Court. This is the case law. This is how you're supposed to go with this. So hear us out. Vigorous advocacy is essential not only to the preservation of individual rights, but also to the integrity of the judicial system, whose truth-seeking process is sought to be protected through the exercise of the contempt power. Courts must be judicious in their approach to adjudicating contempt. In Reed Jefferson, 283 Georgia 216, 221 from 2008, quote, contempt is a drastic remedy, which ought not to deprive one of his liberty unless it rests upon a firm and proper basis. In Ray Johnson, this is the 2022 from Georgia Appeals Court, and it cited Ford v. Ford, a 1998 case. Before holding an attorney in contempt for statements made during courtroom proceedings, the court must find, beyond a reasonable doubt, that 1, the attorney's statement and conduct either actually interfered with or posed an imminent threat of interfering with the administration of justice, and 2, the attorney knew or should have known that their statements and conduct, quote, exceeded the outermost bounds of permissible advocacy. So, beyond a reasonable doubt, and the behavior itself also needs to be the worst of the worst. In Ray Jefferson, at all times, that's from In Ray Jefferson. At all times relevant, Attorney Steele was facilitating the search for truth, not hindering it. And that's cited back to same case. A beautiful sentence here. At all times relevant, Attorney Steele was facilitating the search for truth, not hindering it. Justice must satisfy the appearance of justice. That's Offutt versus United States. That's a 1954 case. There are many instances where the trial court's actions do not reflect an administration of justice. This includes the court repeatedly questioning a single defense attorney about the source of privileged information the judge himself was required to disclose. Powerful sentence. And we're seeing some of the stuff from earlier tie back in here. It was improper and not an administration of justice for Judge Glanville to hold Attorney Steele in criminal contempt with a maximum jail sentence solely because Attorney Steele refused to answer the judge's question when doing so would have required him to violate attorney-client privilege. It was improper and not an administration of justice for Judge Glanville to engage in numerous ex parte communications with prosecutors and a sworn witness and then withhold the existence and substance of those communications from the defendants, while simultaneously depriving them of an opportunity to be heard. It was improper and not an administration of justice for Judge Glanville to interrupt Attorney Steele's repeated attempts to make a record about the court's ex parte communications with a sworn witness and prosecutors. Quote, to sanction such a course of procedure would give it encouragement. And that's citing the Offutt United States case. If Judge Glanville's concerns about the administration of justice were relevant to the, quote, sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, there were other correctives sufficient to address those concerns before Judge Glanville held Attorney Steele in criminal contempt. In Ray Jefferson, 283, Georgia at 221, so they're citing one of the Jefferson cases again. For example, Judge Glanville could have ordered, and later did, all parties who were in attendance during the ex parte hearing to appear before the court to determine the source. Judge Glanville, that was the show cause. Judge Glanville could have ordered all attorneys for defendants to disclose the source of this information. Because Judge Glanville did not understand the nature of the attorney-client privilege asserted by Attorney Steele, he could have gone in chambers and asked. Beautiful, I'm so glad they included this. Because Judge Glanville did not understand the nature of the attorney-client privilege asserted by Attorney Steele, he should have conducted an in-camera review rather than repeatedly asking Steele to reveal his source in open court. Instead of pursuing these reasonable alternatives, Judge Glanville singled out Attorney Steele and held him in direct summary criminal contempt, with the maximum jail sentence simply because Attorney Steele was vigorously advocating on behalf of his client and refused to violate attorney-client privilege by disclosing his source. So see in Ray Lightfoot, that's a Georgia appeals court from 2021, reversing contempt where public defender refused to disclose source because, quote, other actions might have achieved the same result without holding Lightfoot in contempt. Great, that sounds right on point. That sounds right on point, and it's from 2021 with the Georgia appeals court, a lower court than the Supreme Court, reversing contempt against a public defender. Because there could have been other ways. They could have had an in-camera, they could have gone into chambers and said, look, this is why I think this information is privileged. Let me talk to you in here instead of an open court. They could have asked the other attorneys. This is so good to read. I love reading this stuff. Holy moly. It is not criminal contempt for a defense attorney to refuse to violate attorney-client privilege, nor is it criminal contempt when a judge provokes the extraordinary circumstances surrounding the alleged contempt and then refuses to recuse himself after becoming personally embroiled with the attorney. The trial continued after Judge Glanville permitted Attorney Steele to return to the courtroom, even though Attorney Steele did not reveal his source. This indubitably demonstrates that Attorney Steele did not obstruct or hinder the administration of justice. Another good call out. That's something I wouldn't have thought to argue, but that's a good argument. Like, obviously things could continue, so the basis for holding someone in contempt didn't exist by their own decision. And now we're getting to breaking down these arguments. So A, Attorney Steele was vigorously advocating on behalf of his client, and his refusal to violate attorney-client privilege is not criminal contempt. As counsel for Mr. Williams, Attorney Steele had a right to make a record of what he learned about the ex parte communications. An attorney may not be held in contempt of court merely for presenting in good faith a motion in which he has a right to make, nor may an attorney be held in contempt merely because, having filed such a motion, he fails to prevail on it. In Ray McLarty, 152 Georgia Appeals, 399 400 1979, quote, it is essential to a fair administration of justice that lawyers be able to make honest, good faith efforts to present their clients' cases. In Ray McConnell, which is a 1962 U.S. case, where the judge is arbitrary or affords counsel inadequate opportunity to argue his position, counsel must be given substantial leeway in pressing his contention. In Ray Dellinger, another federal case in the Seventh Circuit, doubt should be resolved in favor of vigorous advocacy, and any balancing test for determining whether advocacy interferes sufficiently with justice to make it punishable must also consider the positive value of the advocacy to the very interests sought to be protected by the contempt power. And then we're going back to in Ray Jefferson, the Georgia case. So a ton of case law there kind of spelling it out like, yeah, you shouldn't have been holding Steele in contempt. He was just advocating for his client, so what's up? This court held that one of the factors courts should consider in determining whether to hold an attorney in contempt is, quote, the significance of the particular issue in question to the case as a whole, and the relative gravity of the case. That's also from Jefferson. The information Attorney Steele was attempting to put on the record regarding what he learned about the morning's ex parte hearing was of great significance to the RICO case as a whole. This is particularly true in hindsight, considering the exculpatory statements made by Copeland that were not disclosed to the defendants and Attorney Steele's belief that the ex parte hearing involved coercion and witness intimidation. The positive value in Attorney Steele's vigorous advocacy far exceeds any privacy interest surrounding Judge Glanville's ability to conduct ex parte hearings with prosecutors and a sworn witness. The gravity of the RICO case, involving many serious charges, including murder, is clear. Like the prosecutor who was erroneously held in contempt when he refused to go forward with trial, Attorney Steele was professional and respectful of the bench in carrying out his obligations and responsibilities as counsel for Mr. Williams. So we're going to In re Berger, a Georgia appeals case from 2003. Attorney Steele simply refused to violate his duty of confidentiality to Mr. Williams, to protect Mr. Williams and the sanctity of his attorney-client relationship. Attorney Steele repeatedly explained to Judge Glanville why he could not reveal the information. Conversely, Attorney Steele was threatened with confinement early in the proceedings without any showing of contempt. In re Brookins, that's a Georgia appeals, 1980, there is nothing indicating that Attorney Steele's refusal to violate his ethical obligations by disclosing privileged information, his source, was such an open, serious threat to orderly procedure that instant and summary punishment, as distinguished from due and deliberate procedures, was necessary. And that's Harris v. United States, 1965. Tons of case law. Attorney Steele's refusal, and remember, if we get a response to this, the state already said that they don't want a part in responding to this. They don't feel like they're a party. I don't know how they can kind of argue that when, with Fani Willis helping to draft the immunity order, that seems intimately tied in with June 7th and June 10th. But maybe the Supreme Court will agree that the state itself shouldn't be a party. This is really just Glanville. Whoever has to respond to this, whoever the Supreme Court deems is the party that needs to respond, needs to address each of these. And I'm waiting to see the response. Will we even get case law arguing a counterpoint for half this stuff? Will we see them try to reinterpret the purpose of this ex parte meeting, the two ex parte meetings? So think about that as we get through the rest of these arguments, what their response could or might be. Attorney Steele's refusal to violate attorney-client privilege without his client's permission is not criminal contempt. We're starting with a common sense, a black letter of the law type argument. Like, duh, right? You guys in the chat, put a 1 in the chat if this is common sense to you. If you understand this as a layperson, that Attorney Steele's refusal to violate attorney-client privilege without his client's permission is not criminal contempt. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. Comment 5, Rule 1.6, quote, that a lawyer maintain confidentiality of information relating to the representation is a fundamental principle in the client-lawyer relationship. And look at you guys. Look at you guys. Look at all the lay people in the chat understanding this common sense thing that Judge Glanville tried to push back on. Shout out to us lay people. There we go. We got an Uno. Shout out to you guys in the chat. Comment 5, Rule 1.6, that a lawyer maintain confidentiality of information relating to the representation is a fundamental principle in the client-lawyer relationship. The attorney-client privilege is the oldest of the privileges for confidential communications known to common law, and has long been recognized in Georgia. The privilege belongs to the client, not the attorney. So even if Steele wanted to violate it, it's not his duty to say, all right, Judge, just because you asked me to, I'm going to make the decision because I can make that decision to disclose something to you. Judge Glanville never looked over at Jeffrey Williams and said, hey, do you want to give permission to disclose this? Do you want to disclose it? He only asked Steele. The privilege belongs to the client. It is essential to constitute a contempt that the thing ordered to be done be within the power of the person against whom the order is directed. Great argument. This inability to comply would have been ground of defense before the judgment of contempt. Just as the attorney in Ray Brookins was unable to proceed to trial, so too was attorney Steele legally and ethically unable to answer Judge Glanville's question. Doing so would have required attorney Steele to reveal privileged information that he, attorney Brian Steele, was not authorized to share, thereby destroying the duty of confidentiality he owes to Mr. Williams and causing irreparable harm to the attorney-client relationship. Additionally, if attorney Steele answered Judge Glanville's question and revealed his source, the applicability of the attorney-client privilege to that information would have been rendered moot. Judge Glanville's decision to hold attorney Steele in criminal contempt for refusing to violate attorney-client privilege is analogous to the judge in Maness v. Myers. That's a 1975 U.S. case, holding the attorney in contempt for advising his client, in good faith, to refuse to produce court-ordered materials on the ground that the materials may tend to incriminate the client in a further proceeding. If performance of a lawyer's duty to advise a client that a privilege is available exposes a lawyer to the threat of contempt for giving honest advice, it is hardly debatable that some advocates may lose their zeal for forthrightness and independence. An advocate is not subject to the penalty of contempt for advising his client, in good faith, to assert the Fifth Amendment privilege against self-incrimination in any proceeding embracing the power to compel testimony. To hold otherwise would deny the constitutional privilege against self-incrimination the means of its own implementation. And that's from the Maness case. Attorney Steele asserted attorney-client privilege as the basis for refusing to answer Judge Glanville's question in good faith, and he was in no way contumacious in doing so. Had attorney Steele complied and answered Judge Glanville's question, there would have been irreparable injury, because appellate courts cannot always unring the bell once the information has been released. Subsequent appellate vindication does not necessarily have its ordinary consequence of totally repairing the error. That's Maness. This court should extend the sound reasoning in Maness to the facts currently before the court and find that an attorney cannot be held in contempt for asserting attorney-client privilege on behalf of a client or advising their client to do the same. Now, that's the end of argument A, so one grounds. And with the Supreme Court, they can rule in part, they can disagree with all of it, they can agree with all of it, but we should see the Supreme Court of Georgia acknowledge each of the arguments. And I think argument A is great. I loved reading that. So we're now going to look at B, which is Judge Glanville should have recused himself from the contempt proceedings because he provoked the extraordinary circumstances giving rise to the alleged contempt and became personally embroiled with attorney Steele. Appellant Steele's conduct cannot fairly be considered apart from that of the trial judge, and that's from Offit, a U.S. case. An important factor courts must consider when determining whether to hold an attorney in contempt is the extent, if any, to which the trial court provoked the offending statements with its own improper statements. So in Ray Jefferson, lots of Jefferson citations here, which also cited Little, a U.S. case. Trial judges must be on guard against confusing offenses to their sensibilities with obstruction to the administration of justice. The contempt power entrusted to a judge is wholly unrelated to his personal sensibilities, be they tender or rugged. Courts should limit their orders to the least possible exercise of power required. Let's read that again. Courts should limit their orders to the least possible exercise of power required. In layman's terms, it says no power tripping, and should not impose punishment without first affording minimum due process to the accused. But what did we get here with Glanville? We got max sentencing. Deal with it later. You can look at the transcript later. For now, you'll get the max. And now we're getting to we get CJ CR 29 and US CR 21. So this is more authority, not coming from case law, but coming from different rules. Judge Glanville's failure to comply with Code of Judicial Conduct Rule 29 provoked the extraordinary circumstances giving rise to attorney Steele's alleged contempt. I think Rule 29 is the one about ex parte meetings and how the court isn't supposed to look or seek information that's off the record. Let me just double check that. Yeah, the ex parte rule. So let me just pull this up quick so you can see. we've looked at this a lot. I think that's why Rule 29, I remember it now. The judge shall not permit or consider ex parte communications, blah, 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 except for these 4 exceptions or 5 exceptions. I'll paste this rule, but we know the basics of it. And that is a long Google link. Let me make sure I get the correct link for you guys. So there you go. If you want to take a deeper look at Rule 29, we've gone over it a lot. Where was my share? Was it this one? There we go. So talking about Rule 29 here. So Judge Glanville's failure to comply with the code, the established code, provoked the extraordinary circumstances giving rise to Attorney Steele's alleged contempt. They also give a footnote here citing to USCR 41, which says that ex parte communications are presumed to have been in error. Copeland's testimony was an impending matter that was extremely important and possibly pivotal. Possibly pivotal. Yeah. I mean, look how many people were just stunned and astonished by what came out through Kenneth Copeland's testimony and or those videos. Possibly pivotal to the ongoing RICO trial. Judge Glanville specifically advised all parties, including Attorney Steele, in open court that he would address Copeland's testimony when court resumed Monday morning. There was no legitimate reason for the state to request ex parte communications with Judge Glanville, Copeland, a sworn witness, and his counsel, especially when they knew his counsel was going out of town. Well, that's my addition there. Judge Glanville should have immediately stopped the state's attempt to engage the court in these improper communications. So it's Judge Glanville's fault. He started the problem. He knew he shouldn't have done this, and it's not Brian Steele's fault that he responded to this thing that never should have happened in the first place. Judge Glanville's suggestion to Copeland that he was the one requesting the ex parte communications, the I, we saw it underlined and bolded, I am bringing us here. Judge Glanville's suggestion to Copeland that he was the one requesting the ex parte communications was also a violation of CGR CR 29 because judges are not permitted to participate in or initiate such communications, even if done with good intentions or no intention of favoring one party over another. The footnote here says, see this inquiry concerning Anderson and inquiry concerning Peterson. So they're citing these, this is Judge Peterson, Christina Peterson. So they are citing what's the commission called? The Judicial Qualifications Commission. So there was an inquiry made, and the Judicial Qualifications Commission put a report together and brought that report to the Georgia Supreme Court. I don't know the backstory on Anderson, but I'm assuming it's the same procedure. So the Judicial Qualifications Commission issues their report, Georgia Supreme Court reviews it. They agreed with 4 of the issues raised and ruled that it was worth removing her from the bench. And one of those issues was about a contempt proceeding that involved scheduling that the court clerk participated in, not even the judge directly. A second issue involved the Judge Peterson holding a party in contempt for the maximum incarceration amount when the maximum wasn't warranted. And we looked at that on another stream. A lot of people have talked about that, but they are citing this. This just happened like 2 months ago, maybe at this point. And they're putting it in a footnote here. Very interesting to see. Now let me go back up to this footnote. I don't remember where I was. Where was 6? Okay. So Judge Glanville did not present an appearance of a fair and impartial judge when he failed to comply with CJ CR 29 and told Copeland he had an interest in hearing Copeland's testimony. Even when Attorney Steele inquired about the cause of the delay, before Copeland took the stand, Judge Glanville withheld information about the ex parte hearing and suggested that Copeland's counsel was the only person Copeland spoke to before he decided to testify. It was Judge Glanville's duty to disclose to Attorney Steele and counsel for the other defendants the existence and substance of the ex parte communications that occurred in chambers with Copeland that morning and all other times, and to afford the defense an opportunity to respond. The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. Judge Glanville also did not present the appearance of a fair and impartial judge when he failed to abide by the well-established procedures for sealing public records set forth under Uniform Superior Court Rule 21. USCR 21 creates a presumption that all court records are to be open to ensure the public's continued enjoyment of its traditional right to access judicial records. And this is the Savannah School of Art and Design versus School of Visual Arts, a 1999 case. USCR 21 through 21.6 established specific procedures that courts must follow before shielding such records from public view. And that's Altman versus Altman 2017. As the party seeking to seal the June 10, 2024 ex parte transcript, Judge Glanville failed to meet his burden of demonstrating that the harm to the privacy right he was asserting clearly outweighed the public's substantial interest in access to the records. This was, so this is an Atlanta Journal-Constitution case. Shout out to AJC from 1999. So this seems like a case where AJC was fighting for public access to records. Shout out to AJC. Tons of coverage on all things Fulton County and this YSL case. Judge Glanville did not hold a hearing on his decision to seal the transcript, despite Attorney Steele and the defendant's numerous requests for a copy. USCR 21-1, Attorney Merchant, counsel for Attorney Steele, requested a copy of the transcript in open court because it is germane to the contempt. Judge Glanville denied this request. The requirement of a hearing held upon reasonable notice is indispensable to the integrity of the process mandated for limiting access to the court records. So that's that AJC case. So shout out to, back then, that's decades ago already, 1999, but AJC, I talk about Joseph Papp a lot. He's a writer, he's a contributor to AJC, bringing tons and tons of transparency into this case and tons of other cases. They've been doing it for decades. Judge Glanville did not specify, quote, the nature and duration of the limitation and the reason for limitation. USCR 21.1, nor did he make a finding that the harm otherwise resulting to the privacy of a person in interest clearly outweighs the public interest, and that's USCR 21.2. It is insufficient for the trial court to forgo making findings of fact and simply state that the public's interest in access to court records is clearly outweighed by potential harm to the party's privacy. And that's again from the AJC case. No compelling circumstances were present, and Judge Glanville did not file an ex parte order granting his purported, quote, motion for temporary limitation of access that required a supporting affidavit. Ooh, they got the whole procedure womped down here. So, USCR 21.3, justice faces its gravest threat when courts dispense it secretly. Our system abhors star chamber proceedings with good reason. Like a candle, court records hidden under a bushel make scant contribution to their purpose. And that's from a different Atlanta Journal versus Long. That is from 1988. And we get bolded quote, publicity is the very soul of justice. So footnote 7 here is citing, and this is where we get some of that like kind of expert analysis, legal analysis from David Ardia, in a writing called Court Transparency and the First Amendment, published in 2017. And this case illustrates the importance of the right to access court records that is indispensable to defendants and the public at large. Number 8 footnote says, including the transcript of the Friday ex parte communications between prosecutors and Glanville, that was not prepared or provided to Attorney Steele and the defendants until after Judge Glanville was recused, because remember, Whitaker was like, oh, we found out about another transcript. Anything else we need to know about? Were there any other ex partes? So we get that long after Judge Glanville was recused. It was improper for the trial court to keep this material entirely off the record. So go back up here. It continues to read that suppose the proceedings to be completely secret, and the court, on the occasion, to consist of no more than a single judge, that judge will be at once indolent and arbitrary, how corrupt soever his inclination may be. It will find no check, at any rate, no tolerably efficient check, to oppose it. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. Recordation, appeal, whatever other institutions might present themselves in the character of checks would be found to operate rather as cloaks than checks, as cloaks in reality, as checks only in appearance. And I love that we can tell that this case is, 1948 would probably be a close ballpark guess based on the verbiage here. So that's from In re Oliver from 1948. That's a U.S. case. But really it's saying, like, without the sunlight, how would we be able to keep checks in place? How do we check something if we don't know what's happening? By violating CJCR 29 and the procedures set forth under USCR 21, Judge Glanville provoked the extraordinary circumstances giving rise to Attorney Steele's alleged criminal contempt, rendering any finding of contempt moot. Now, the personal embroilment. It is expecting too much of any trial participant to silently suffer the abuse of the court. Such abuse should negate the wrong intent of counsel. We get a footnote here to another, expert legal analysis by Louis Ravison, Advocacy and Contempt Part 2, Charting the Boundaries of Contempt, Ensuring Adequate Breathing Room for Advocacy. And that's a publication from 1990. As an Offit, Judge Glanville became personally embroiled with Attorney Steele. Judge Glanville did not question any of the other defense attorneys or hold them in contempt, even though they had the same information about the ex parte hearing as Attorney Steele. There was nothing Attorney Steele did to warrant Judge Glanville's personal embroilment with him. This one-sided personal embroilment requires Judge Glanville to recuse himself from the contempt proceedings. And now, also, just as a side note, what I think is important here, I remember one of the defense attorneys getting up saying, and quite frankly, we're still in the dark. But we do have at least one other motion. I think it was Doug Weinstein that filed it. So we have these affidavits, we have these motions. I believe it was Doug Weinstein. So at least there's proof that at least one other person, at least within a few days, before the recusal of Judge Glanville, had the same information. So they became aware of the same information. So I bet you will get a counter argument that, hey, one of them said, quite frankly, we're still in the dark. But it doesn't matter because they all learned of the information that Brian Steele had. So, but I'm expecting that to be one counter argument. But yeah, this one-sided personal embroilment required Judge Glanville to recuse himself from the contempt proceedings. The record discloses not a rare flare-up, not a show of evanescent irritation, a modicum of quick temper that must be allowed even judges. The record is persuasive that instead of representing the impersonal authority of law, the trial judge permitted himself to become personally embroiled with the petitioner. There was an intermittently continuous wrangle on an unedifying level between the two. For one reason or another, the judge failed to impose his moral authority upon the proceedings. His behavior precluded that atmosphere of austerity, which should especially dominate a criminal trial and which is indispensable for an appropriate sense of responsibility on the part of the court, counsel, and jury. Such an atmosphere will also make for dispatch insofar as in consonant with a fair trial. The manner in which this trial was conducted doubtless contributed to the wastefulness of 14 trial days. Oh my god, you can almost add a digit to that. The manner in which this trial was conducted doubtless contributed to the wastefulness of 14 trial days for a case of such limited scope as was the Peckham prosecution. Oh boy. I bet they loved including this. Oh, wasting time for 14 days? And that's from Offit. Judge Glanville reacted to the conduct in such a manner as to have become involved in the controversy, thereby requiring the contempt hearing to be held before another judge. In Ray Hatfield, that's the Georgia appeals case from 2008, Judge Glanville was personally offended when Attorney Steele stated on the record that he was aware of the improper ex parte hearing that Judge Glanville should have disclosed. Judge Glanville's personal embroilment with Attorney Steele is clear, given the numerous inflammatory, baseless allegations he made against Attorney Steele in open court without giving Attorney Steele an opportunity to respond. He repeatedly interrupted Attorney Steele's continued efforts to make a record. Yes, he did. In Ray Sprayberry, a Georgia appeals case, the transcript also shows that the trial court repeatedly interrupted Sprayberry as she attempted to explain herself. They even got the case law on the interruptions. Judge Glanville singled out Attorney Steele and did not ask anyone else to reveal the source. Judge Glanville was required to recuse himself from the contempt proceedings because he became personally embroiled with Attorney Steele and was the primary witness in the contempt proceedings. And remember, this was really the findings of Judge Krause. Like, Judge Krause didn't really call it embroilment, but, the idea that the parties just inherently were in conflict now that they were taking this case up to fight the contempt. But in a way, this argument is saying that it was even worse. It was personal, it was embroilment before this contempt issue was filed as an appeal. One cannot be both the prosecuting witness and the judge in our judicial system. Here, the trial judge imposed upon Attorney Steele the sanction of jail time without having first afforded him meaningful opportunity to defend himself against the trial judge's conclusion that his conduct was contemptuous. The attorney was personally charged by the judge with unprofessional conduct, and no appeal could be taken from the judge's remarks. Can a judge make such a charge and deny the attorney the right to answer? Must the attorney stand silent and helpless in face of such a charge? Is it contempt of court for the lawyer to insist that he is entitled to answer the charge? A charge that an attorney is guilty of unprofessional conduct is a serious charge and is even more serious and damaging when made by a judge in open court. Fundamental fairness requires that the attorney be given reasonable opportunity to answer such a charge. A judge has no right to make such a charge and then deny the attorney the right to be heard, and it is not contempt of court for the attorney to insist on being heard. Of course, the attorney does not have unlimited time to be heard, and his answer must be in a respectful manner, but he does have the right to be heard and should not be penalized for attempting to exercise that right. And that's a new one. This is a DC case in Ray Absey. A hearing, and only a hearing, will elucidate all the facts and assure a fair administration of justice. Then, courts will not act on surmise or suspicion, but will come to the sentencing stage of the proceeding with insight and understanding. Make Glanville testify. The right to be heard in open court before one is condemned is too valuable to be whittled away under the guise of demoralization of the court's authority. That's from In re Oliver. Trial judges must disqualify themselves where their impartiality might reasonably be questioned. Attorney Steele had a right to be heard by an impartial judge on the alleged contempt, and Judge Glanville denied Attorney Steele that right by refusing to recuse himself from the contempt proceedings. Judge Glanville was a necessary witness, and he should have recused himself after becoming personally embroiled with Attorney Steele. Judge Glanville erroneously refused to recuse himself and deferred the issue to the appellate courts to decide whether he abused his discretion. Oh, this is great. Attorney Steele was engaged in the type of vigorous advocacy that this court and courts throughout the nation, including the United States Supreme Court, have encouraged. It was not criminal contempt. Well, that was a big scroll, my bad. It was not criminal contempt for Attorney Steele to refuse to violate attorney-client privilege by answering Judge Glanville's question regarding his source. It was not criminal contempt when the trial continued after Judge Glanville released Attorney Steele from the holding cell to return to court. Judge Glanville had alternative measures he could have pursued to obtain the information he sought, but he chose to target Attorney Steele instead. There was no criminal contempt because Judge Glanville provoked the extraordinary circumstances giving rise to Attorney Steele's alleged contempt, and he was required to recuse himself from the contempt proceedings after becoming personally embroiled with Attorney Steele. So, respectfully submitted on this 11th day of September 2024. It's within the word count limit. And again, shout out, we've got Hunter Rogers, Maisie Lynn Garreton, Jessica Jones, Greg Willis. And then all of the, everything that they've cited here, we've got the transcripts. Let me link this to you guys in case you want to read it on your own. Thank you again to Beck and Thugger Daily. So there is the brief. What do you guys think? What do you guys think?